It's 3 weeks after your mother's funeral. The casseroles have stopped coming. You're finally sleeping a little. And then an envelope arrives from the state. You almost don't open it because you assume it's one more piece of paperwork to close out. But you open it, and inside is a letter that says the state intends to file a claim against your mother's estate for $153,000. The house you grew up in, the house you assumed was yours now, the house you'd already started imagining your own kids visiting. The state wants it, or wants the money it's worth, to pay itself back for the nursing home care that kept your mother comfortable in her last 2 years. I want you to sit with how cruel the timing of that feels, not because the state is evil, it isn't, and by the end of this I'll have shown you it's actually following a federal law that's been on the books since 1993, but because almost nobody sees it coming. The home was exempt while your mother was alive. Nobody at the nursing home mentioned it. The Medicaid application had a form about it, buried on page 9, that someone signed without reading. And so the first time most families learn the words estate recovery, they learn them in a letter that arrives 3 weeks after the funeral. Here's what I want to do for you today. I'm going to tell you about 2 families. They started in almost exactly the same place, same kind of parent, same kind of house, same kind of nursing home bill. One of them lost the house, the other one kept it, completely legally, and the difference between them was not money and it was not luck. It was about 9 specific decisions, most of them made years before anyone died. By the end of this video, you're going to know which family you're currently on track to become and exactly what to do to switch tracks if you need to. I'm not your lawyer, and I'll say that more than once, but I am going to hand you the map. Before I say anything else, let me be clear about one thing. Because the fear around this is bigger than the reality, and the fear itself does damage. People are so afraid of this letter that they refuse to apply for Medicaid their parent genuinely needs. They let a parent suffer without care because they heard Medicaid takes your house. So hear this plainly. Medicaid cannot take your house while your parent is alive. It cannot. What we are talking about today happens only after death, and only under specific conditions, and there are real legal ways to prevent it. Do not let the fear of estate recovery stop you from getting your parent the care they need right now. That's the worst possible outcome, and it's the most common one. Now, let me tell you about the 2 families, and as I go, keep one question in the back of your mind. I'll come back to it at the end. Which of the 9 decisions was the one that actually decided everything? Because there's one in particular, and it's not the one most people guess. Let me start by telling you what this program actually is, because you cannot plan against something you don't understand. It's called the Medicaid Estate Recovery Program. Elder law attorneys shorten it to MERP. It is not a state being greedy, and it is not optional for the state aid. It's a federal mandate. Back in 1993, Congress passed something called the Omnibus Budget Reconciliation Act, and one piece of it required every single state to try to recover what it spent on long-term care for people aged 55 and older after those people die. Before 1993, recovery was up to each state. After 1993, every state has to do it. So when that letter arrives, the state isn't picking on your family. It's following a law it isn't allowed to ignore. Here's the part that catches everyone. While your mother was alive and on Medicaid, her home was an exempt asset. That's a real protection, and it's why she could qualify for Medicaid without selling the house first. But exempt while living does not mean safe after death. The home is usually the very last thing of real value a person who needed years of nursing care still owns. The savings are gone, spent down to qualify in the first place. So the home is exactly what the state looks at. The thing that was protected during life becomes the thing most exposed at death. Nobody explains that gap, and that gap is where families fall. What can the state actually recover? It's the cost of long-term care, nursing home care, in-home care delivered through Medicaid waiver programs, and the hospital and prescription costs tied to that long-term care. And there's a ceiling that matters. The state can never recover more than it actually paid. If Medicaid spent $153,000 on your mother and her house is worth $300,000, the state can claim $153,000, not a penny more. The rest is still your family's. That's a real limit, and it's worth knowing, because the panic in that first letter makes people think the state takes everything. It takes, at most, what it spent. So now you understand the machine. Let me show you the 2 families walking into it. Family 1. I'm going to call the mother Dorothy, and I'll tell you right now, the way I always do, that Dorothy and everyone else in these stories is a composite. Names change, details combined from common situations, no real family. I do that on purpose, so I can show you the patterns honestly without exposing anyone real. Dorothy is 79. She has a modest house paid off worth about $280,000. She has one daughter, Karen, who lives 40 minutes away and visits on weekends. Dorothy starts slipping, falls, forgets the stove, the usual frightening signals. Within a year, she needs full nursing home care. Karen does everything right in the moment. She finds a good facility, she applies for Medicaid, she's there every Sunday. The house sits empty. Dorothy lives 2.5 more years in care, and Medicaid pays about $190,000 over that time. Dorothy passes. 3 weeks later, the letter comes, and because Karen did nothing with the house, because the house passed through Dorothy's probate estate exactly as it was, the state files its claim, and to pay it, the house has to be sold. Karen nets the difference, but the home, the actual home, is gone. That's family one. Now hold Karen's story right there, because I want you to see how close family 2 started to the exact same place. Family 2. The mother here I'll call Lillian. Same disclaimer, a composite. Lillian is also in her late 70s. Also a paid-off house, worth about the same. Also one adult child, a son I'll call Marcus, almost identical starting line. But somewhere around the time Lillian turned 74, years before any crisis, Marcus did something Karen didn't. He sat down with a certified elder law attorney for one afternoon. Not because there was an emergency, because there wasn't one yet. And in that one afternoon, the whole back half of this story got rewritten. We'll get to exactly what they did. First, I need to show you the doors that were open to them, the legal exits from estate recovery, because these are the same doors open to you right now. Here's the first thing that determines almost everything, and most people have never heard of it. Whether you live in a probate-only state or an expanded recovery state, this single fact changes the whole game. Let me explain it simply. When someone dies, some of their assets pass through a court process called Probate E. That's the formal public process where a will gets validated and assets get distributed. But a lot of assets skip probate entirely. A life insurance policy with a named beneficiary skips probate. A bank account that's payable on death to someone skips probate. A house held the right way can skip probate. Now, in 23 states and Washington, D.C., the Medicaid Recovery Program is only allowed to come after assets that went through probate. That's it. If an asset skipped probate, in those states, it's out of reach. Those are called probate-only states. But in the other 27 states, expanded recovery states, the program can reach assets that skipped probate too. Same death, same house, completely different exposure, depending entirely on which state you're standing in. And this is the first place I have to stop and put up the flag I'll keep raising. You have to know your own state. I cannot tell you in a video whether your state is probate only or expanded, because there are 50 different answers, and they change. California and New York have always had their own wrinkles. California in particular just reinstated an asset limit in 2026, $130,000 for an individual dies after years without one, and that changes the planning math for any family dealing with Medi-Cal, which is what California calls its Medicaid program. So when I describe a strategy, your homework is always the same. Confirm it for your state, with someone licensed in your state. The map is the same shape everywhere. The exact roads differ. Okay, the doors. The legal ways families avoid or survive estate recovery. I'm going to give you the main ones. And as I do, you'll start to see which doors Marcus walked through and which ones Karen never opened. Door 1, and this is the biggest one for most families, the surviving spouse protection. This is federal, it's in all 50 states, and it's absolute. The state cannot recover while there's a surviving spouse. It also cannot force the sale of the home while the surviving spouse is living in it. So if your father is on Medicaid and your mother is still alive and in the house, the state cannot come for that house while she's there. Now, an honest caution. In some states, after that surviving spouse later dies, assets that passed from the Medicaid spouse to them can still be reached. So this is often a powerful delay, and in many situations more than a delay, but you have to know your state's rule on what happens at the second death. Door 2. Protected survivors beyond the spouse. The state also cannot recover if the deceased is survived by a child under 21 or by a child of any age who is blind or permanently disabled. That protection follows the child, not the calendar. If your parent had a disabled adult child, that alone can block recovery entirely. Door 3. The sibling exemption. If a brother or sister of the Medicaid recipient has an ownership interest in the home and lived there for at least 1 year before the recipient went into care, the home can be transferred to that sibling without triggering a penalty. Narrow, but real for the families it fits. Door 4. And this one is for the caregivers watching, and I suspect that's a lot of you. The caregiver child exception. This is for the adult child who moved in and took care of mom or dad. If you lived in your parents' home for at least 2 years immediately before they went into a nursing facility, and your care is what kept them out of that facility during those 2 years, the home can be transferred to you legally without a Medicaid penalty. Think about who that protects. It protects the daughter who quit her job and moved back into her childhood bedroom to keep her father at home for 2 extra years. The law actually recognizes what she did. But, and this matters, you have to be able to prove it. States want documentation, a doctor's statement that your care delayed institutionalization, dated records, the real paper trail. The protection is real, but it is not automatic, and it is not retroactive if you can't show your work. Door 5. The undue hardship waiver. Every state is required to have one. This is the door you knock on after the letter has already arrived, when recovery would genuinely devastate the survivors. The classic case the states recognize: the estate is the family's sole income-producing asset, the family farm, the small business that the heirs actually live on. Some states also waive for heirs below an income threshold or for homes of genuinely modest value relative to the area. But hear the warning inside this door, because it's the most dangerous deadline in this entire topic. Hardship waivers have short windows, often 30 to 90 days from the date of that notice. If you get the letter and you set it aside because you can't deal with it yet, which is the most human thing in the world 3 weeks after a funeral, you can miss the window, and a claim that could have been waived becomes a claim that's simply owed. If a letter like this ever comes, that envelope is a clock. Open it the day it arrives. Now let me show you the doors you walk through before death, the planning doors. These are the ones Marcus used. There's a tool called a life estate deed. In some states, a particular version of it is nicknamed a ladybird deed. The idea is that your parent keeps full control and full use of the home while they're alive. They can live in it, sell it, do whatever they want. But the deed is set up so that the moment they die, the home passes automatically to the named child. Automatically means it skips probate. And in a probate-only state, skipping probate can mean skipping recovery. There's also the Medicaid Asset Protection Trust, a specific kind of irrevocable trust that, if it's set up at least 5 years before applying for Medicaid, can move the home outside the reach of both the program's eligibility math and recovery. That 5-year number should sound familiar if you watched my video on the look-back rule. It's the same 5-year window, and it's exactly why this is something you do early, in a calm year, not in a crisis. And that's the thing I most need you to take from these two families. Go back to Marcus. What did he actually do that Karen didn't? He didn't have more money. He didn't have a secret. He had time, and he used it. The afternoon he spent with that elder law attorney when his mother was 74, years before she needed a thing, is the entire reason Lillian's house is still in the family today. Karen loved her mother every bit as much. Karen showed up every Sunday, but Karen acted only when the crisis was already here, and by then most of the doors were already closing. The cruelest truth in this whole area of law is that the best protections are the ones that take years to ripen, which means the worst time to learn about estate recovery is when you need it, and the best time is a quiet, ordinary week like this one, when nothing is wrong yet. So let me answer the question I asked you to hold at the start. Of the 9 decisions, which one actually decided everything? It wasn't the deed, it wasn't the trust, it wasn't even knowing whether the state was probate only. Those were all just consequences. The decision that decided everything was the decision to look at this at all before it was an emergency. Marcus made that decision at an ordinary kitchen table on an ordinary afternoon. That's the one. Everything else followed from it. Here is your next action plan, concrete and short enough to actually do. First, today, find out one fact. Is your state a probate-only state or an expanded recovery state? That single answer reshapes everything else, and you can start by searching your state's name with the words Medicaid Estate Recovery. Second, locate the deed to your parents' home and find out exactly how it's currently titled. Not how you think it's titled, how it actually reads. That's the document everything turns on. Third, and this is the real one, if your parent still has time and capacity, book one consultation with a certified elder law attorney, a CELA, in your parent's state, one afternoon. That's the whole Marcus difference. Bring the deed. Ask them specifically about the caregiver-child exception if anyone in the family has been providing care, about a life estate deed or a Medicaid asset protection trust, and about your state's exact recovery rules. And fourth, if a recovery letter has already arrived, do not wait. Treat it as a clock running. Call an elder law attorney that week and ask immediately about the undue hardship waiver and its deadline, because that deadline may be measured in weeks. This is the part I want to leave you standing on, because the whole point of understanding this is to stop being afraid of it. Estate recovery is not a trap door that opens at random under grieving families. It is a known law with known exits, and the families who keep the home are simply the families who found the exits early. You are watching this, which means you're already ahead of where Karen was. You have the map now. The only thing the map can't give you is time. So if your parent has time, that's the asset to spend this week, while it's still yours to spend. One last thing, and then I'll let you go. Everything I've told you today is the after, what happens once a parent has already needed years of care. But there's a question that comes before all of it, the one that quietly determines how big that recovery number ever gets in the first place. How a family pays for the very first stretch of care, before Medicaid ever enters the picture. That's where the real money is won or lost, and that's exactly where we're going next time. I'll see you there. This video is educational only. It is not legal, tax, or financial advice. Estate recovery rules vary by state and change, so please confirm your state's specific rules and consult a certified elder law attorney and a tax professional before acting on anything here.